Maintenant, nous souhaitons la bienvenue à une collègue estimée, une amie qui fait un travail fantastique depuis des années à Arusha et qui n'a que des amis. Il s'agit de Beth Lyons. Et je vais utiliser le texte des notes pour les fins de nos archives. Beth Lyons est une avocate de la défense au Tribunal pénal international pour le Rwanda, où elle a représenté 3 accusés. Elle est avocate accréditée à la Cour pénale internationale, au Tribunal Spécial pour le Sierra Leone et jusqu'à récemment au TPIY. Bienvenue et merci beaucoup.
Merci, monsieur. Merci pour c'est une grande introduction, mais je peux parler en anglais parce que mon français n'est pas exactement correct. Okay. I'm criticized too much. First of all, I want to say it's both a privilege and pleasure to be here among my colleagues from Arusha, my colleagues from the other tribunals, members of the Rwandan community, members of the Canadian bar and other bars, and hopefully soon to become members of the bars in their various national jurisdictions. And I want to say thank you very much for inviting me. And it's pleased to be the 3rd defense conference and to come here and not having done any work on the organizing committees I did in the first 2. So, it's also, I'm lucky in the sense that I can refer back to the comments of all my colleagues before, many of whom have touched on critical issues which I don't have time to discuss. But the comments, particularly from Charles Taku and others, on the basis of the selective prosecution, the question of there being a policy and practice in the prosecution's office, politically motivated, to decide what will be investigated and what cases will be pursued to the point of prosecution. And the same phenomena at a national level, of course, on the Hutus-only policy in terms of Rwanda, which has been touched on already. What we do, I mean, I'm a defense attorney. We fight legal cases in a context that's dominated by politics at the tribunals. When we walk into the courtroom, and even before, we know that there are a number of parties in that courtroom. There's the judges, of course, but the parties are the defense, the prosecution, and then on that side is the state of Rwanda. So we really are dealing with 2 adversaries. We fight for fairness and for the rights of our clients, but as lawyers fighting legal cases, we use the tools of our trade, and I've been asked to talk about evidence, not a very exciting topic, but a critical topic in terms of the errors, the rights, the errors made by the judgments, the rights of our clients, and in my view, what is going to be and what is a legacy of illegitimacy of decisions of conviction by the international criminal tribunals. I'm not going to talk about the ICTY. I have never done a case there, so I don't feel I can talk about that. So I'm going to leave my comments to the ICTR. Now, all of us in this room, either as defense attorneys or members of families or as students who may have worked on cases or as just people, you know, whether we're political people or we're journalists, whoever, you know, went to visit a trial to watch what happens, can recall, you know, le grand cauchemar, the nightmares that Philippe La Rochelle and others have talked about. What happens in a case? Some of what happened in the Simba case is in one of the articles that I have here, so I'm not going to go through that. And we all, in fact, use some of the same language. It's no accident we're all talking about international injustice. And I just want to briefly say that term has been used by many people, and I want to also say it's the title of a book by John Floyd, who is here, who was Ngesi's lead counsel in the media case. And it's important. There's no mystery about evidence, it's rules. The question is, what do you do about it and what do they result in? Evidence is really about finding facts. In a criminal case, the judges, or because there aren't juries at ICTR, the judges just have to determine whether the prosecution has met its burden of proof based on the charges in an indictment. The defense, really, we could do nothing. We don't have to say anything. We don't have to present any evidence. It's up to the prosecution. That's not what in reality happens, but that's where the burden is, and that's where we as defense counsel fight to keep it. Now, if anyone has ever heard about or watched an Arusha trial, for example, you know immediately, whether you're sitting in the, in the audience or you're sitting, in the courtroom, and you're listening to a prosecution witness, there's something askew here. Now, the witness evidence is not always credible. It's not always reliable. And while it may be presented as factual, I'm testifying about facts of what I saw on X day in X parish, when the defense counsel starts to cross-examination, some details emerge, and it's a questionable whether that witness was at X location, like he or she said, or whether maybe she was at Y location, as she had told OTP, Office of Prosecutor, investigators, 10, 15 years before, in a statement given to the prosecutors of the ICTR. Or a witness will describe an event as if he or she were an eyewitness to that event, when in fact, with a little probing, you learn that it's not what he or she saw. He or she was maybe in the next town or the next street or was not even around that day, but it's what he or she heard from a neighbor, if you're lucky, one level of hearsay, or somebody told somebody else, right? 2 levels, 3 levels. I mean, it's multiple levels. I mean, hearsay is something we always struggle with in law school, and you sort of learn it well in practice at these trials. What happens is that the judgments of criminal conviction really are, in the words of Professor Nancy Coombs, really what happens is it's fact-finding without facts. The judges pretend they're fact-finding. They present their conclusions as if they're fact-finding, but it's without facts. Now, let me just say, before I talk about Nancy Coombs' book, which is called Fact-Finding Without Facts, The Uncertain Evidentiary Foundations of International Criminal Convictions, let me talk about briefly who she is. She's not a defense counsel. She's not an activist in any community. She doesn't identify, she's not a child of the 60s in the U.S. or the other generations or in other countries, generations. But she is a woman who's now a vice dean and professor of law at William and Mary Law School in Virginia. She's a former law clerk to a U.S. Supreme Court justice, and she also clerked for the Ninth Circuit in California. And what's important about her book, and as you listen to some of her conclusions, is both the conclusions, but who's saying it. It's not me saying it. It's not Maître Tremblay saying it. It's not many people in this room who have years, and many more years than I, with experience at all of the tribunals. But it's somebody who's outside, who read all of the judgments and analyzed them from the late 90s up to 2005 and looked at the judgments and of the ICTR, the Special Court for Sierra Leone, and a special panel in the East Timor.